So, good morning, everyone. Nice group. I appreciate everyone coming out on a Saturday morning. We're excited about this. Hopefully, it's informative for you. It's also the first of what we hope to be several or many of these type of seminars, providing a service to the community, sharing information, bringing together organizations uh, to better inform and um, share their insights. So we've been talking about having an estate planning and legacy giving seminar, to be honest, for years. Um, and so with this being the first one, I was thinking a little bit, um, what's a good way to start? So first off, I should probably say for those of you who don't know me, and I think most of you do, but I'm Phil McChesney. I'm the chair of the Sunshine Cathedral Foundation. This morning, we have a group of, like I said, represented organizations with us. You'll hear from our senior minister here at the Sunshine Cathedral, Reverend Dr. Darrell Watkins, in a minute. We also have Mark Blaylock, the CFO and Legacy Giving, um, Legacy Planning Coordinator for the Our Fund Foundation. We have Jeff Seltzer with Seltzer Law here, and representing PNC Wealth Management, we have Chuck Lane and Marco Crespi. And so they'll share more about themselves. We want this to be a little give and take. We'll try to do a nice Q&A session at the end before the reception. But if you've got that burning question, you're afraid like, oh my gosh, if I don't say it now, I'm going to forget, feel free to raise your hand, and I'm sure everybody will be more than happy to answer as we go through. So a couple things I wanted to share. So one of my favorite quotes is Ralph Waldo Emerson's success, and I'm sure most of you have seen that at some point, but I just want to recite this excerpt. So it says, what is to succeed? To appreciate beauty, to find the best in others, to leave the world a bit better, whether by a healthy child, a garden patch, or a redeemed social condition. To know even one life has breathed easier because you have lived, this is to have succeeded. So for me, that means a lot. I think all of us would like to say, whether it's that friendly voice or that smile or just being there to listen to somebody or giving back in other more meaningful ways, I think that's a great definition of success. And then as I was thinking about this, knowing that we're here not just talking about estate planning and planning for the future, but also legacy giving, and what does that mean? And so the quote from Stephen Covey came to mind. The essence of these needs is captured in the phrase to live, to love, to learn, to leave a legacy. The need to live is our physical need for such things as food, clothing, shelter, economical well-being, and health. The need to love is our social need to relate to other people, to belong, to love, and to be loved. The need to learn is our mental need to develop and grow. And the need to leave a legacy is our spiritual need to have a sense of meaning, purpose, personal congruence, and contribution. And that's a little bit what we're about this morning. And so the Sunshine Cathedral Foundation is part of the Sunshine Cathedral, and our role is one of stewardship and ensuring a legacy to support the missions and ministries of the foundation in the long term. So that's important to us. We do that through the Pillars Society, and Dr. Keith Muller will share a little bit more about that in a moment. But what I'd like to do is both introduce Reverend Dr. Darrell Watkins, our senior minister, but also let him share with you some of the other ways that the Sunshine Cathedral has meaning and touches the greater community here.
It's usually Robert's job to remind us to turn our phones, but Robert's not speaking, so that's Robert's job to remind us to turn our things to silent. So, Robert, uh, just as he was as Phil was talking, I was, because I'm always when we're here in the daytime, captivated by the windows and the lights and the designs that we see on the floor or whatever. And it occurred to me as I'm gazing, as I always do, that these were because of a legacy gift. It was sort of once removed, but it's because someone left money to a foundation member, and he wanted to do this. He got her approval ahead of time before she died, but all of this beauty, and we'd had all of this before, but this remained an unfinished project, and this was because of a legacy gift, all at once completed. And there's lots of things like that. We had 2 campaigns that weren't quite 100% successful. Got a lot done, but they didn't reach their goal. And then the third one was successful, and that was largely because we included Pillars money, legacy gifts. So the property, the bricks and mortar, is supported by the foundation, and the foundation's biggest monies really come from legacy gifts. And so much of what we do is because of this property. We reach out all over the world, but we do it from this property. So our broadcasting ministry, which is very important, is done from this property. And we feed 800 people every week with our food sharing at this property. And we share this with lots of community organizations like Happening Out Television and the Gay Men's Chorus of South Florida and SunServe and several 12-step groups. And so we do all of that from this property. And so the legacy gifts, sometimes people will say, should I support the fundraisers, or should I make a pledge and honor that weekly, or should I leave a gift like my insurance policy when I die? And the answer is yes. Because the regular giving is what pays the light bill, but the big gifts are what make the big things possible. And some of us can just make big gifts, but most of us live on salaries or pensions or commissions, and we can't just drop big gifts frequently. But most of us have insurance policies or property or some stocks, and so our legacy giving is the one time that we all can give a big gift, and it makes a big difference. A lot of what we do and a lot of what we have is because people remembered us in their wills and in their estate planning. So it's super important. It's also our shared legacy. This has been going on for over 50 years. Every time someone invests in it, that makes it last longer and do more. So this is 50 years of worshipers' legacy, and we want that to be 100 years and 200 years of legacy. So this is a shared legacy. And as long as this is going on, everyone who's been part of it goes on with it. So that's super exciting. And just also on a very personal level, if you don't have a will, and if it hasn't been updated recently, you really are inviting chaos. I've seen a lot of heartache, people fighting over things. People you think love you can become very vulturistic, circling your grave when it's over. And if you just got plans, that puts all of that to ease. You can leave what you have where you want, to the people and to the charities and to the ministries that you want. So it's a peace of mind for you. And if it includes the church, and whatever includes, it makes that thing, this thing, these things so much more successful, and so much more possibilities come into fruition because of it. So thank you for considering legacy giving. And if you have a lot of money, share it with a lot of people. If you have a little bit of money, share with us. But wherever you share it, sharing does feel good, and it does secure your legacy and gives peace of mind for how we exit the world. So thank you very much for it.
Thank you, Darrell. And without further ado, I think I've already forgot to advance the slide once, so we'll see where I go. Welcome. So at this time, I think that's a great lead in what Darrell was just saying as an introduction to legacy giving. So we're going to hear from Dr. Keith Muller, who's the vice chair of the Sunshine Cathedral Foundation, and then followed by Mark Blaylock from the Our Fund Foundation. Keith?
Thank you, Phil. Good morning, everybody. Thanks for sharing your Saturday morning with us. It's been an honor to serve on the foundation board for many years. As Darrell said, this cathedral and the foundation are a work in progress. We started in a small church through the benefit of people who believed in us. We have this wonderful church and property. And Walt Lawrence and Steve Lewis are those people who helped, among others, like Ron English and Bob Graham and Paul Fasana, to help us get going But that was the beginning. We had needed much more. This property needed a lot of work. We have a large community to serve. And as Darrell said, people giving is the only way we can succeed. One person came to the church and he approached me. He says, "You know, I'm a young man, but I'm going to have several $100,000 for you when I die." Unfortunately, he died very young. Unfortunately for us, we got that money, and that helped us pay off the mortgage. So it's never too soon to plan. It's never too late to plan. But if you do plan, make sure you protect your planning so that what you wish actually happens. Now, to become a member of Pillars is a very simple thing. You send me an email, "I want to be in Pillars." That's all you need. I'll send you an application form to fill out just for contact information. There's a brochure here at the table you can pick up on the way out. What we lack at the foundation is paid staff. So a normal program would have paid staff to keep in touch with Pillars on a regular basis, make sure you're still there, et cetera, et cetera. We're trying to pick up the pieces here. So part of our meeting here resulted in looking at all the Pillars folders, and we have 70 people who received an email from us who were on Pillars. We have no idea how much money that means for us in the future, or even if it's still valid. The good news is they didn't bounce back, so they're still alive and those emails still work. So we can now pursue them as we can in a casual way. What we do like to have on file is any documentation of what type of benefit we should be receiving. A piece of paper stating the church is the foundation of the beneficiary, either the church or the foundation. We want you to do that for us. If you have any questions, ask any of us about it. I don't think you can make a better investment than this church. That's what I have to say. Keep on coming and tell your friends about us. Mark?
Good morning, everyone. My name is Mark Blaylock, and it is my honor to represent our Fund Foundation. And let me just say one quick note, because we're using that word foundation to represent two different organizations this morning. So try not to get too confused. Sunshine Cathedral Foundation is the recipient of your legacy gifts, and it manages the facilities here. Our Fund Foundation is a completely separate organization. We were created 13 years ago. In 2011. And really our primary purpose, as you can see there, is to promote philanthropy. We want to educate the greater community about ways in which they can be philanthropic and leave a legacy that we're talking about. We also love connecting donors with organizations. People are always coming to us and saying, "I have an interest in X, Y, or Z. Who is doing a good job in the area of seniors, of youth, of homelessness?" So we really do connect people. And the third thing that we do is we give a platform for giving. So it's not just legacy giving, but we can help you with your current giving as well. We manage enduring endowments. And this is both for individuals and organizations. And I'm proud to say that the largest endowment that we currently manage is the endowment that Sunshine Cathedral has sent to us. So we do it for both individuals and for organizations. And all of this we do through a lot of grant making, and you're certainly aware of that. Why do we do all this? The ultimate purpose is to improve the lives of LGBTQ individuals right here in South Florida. That is our goal, so we're always looking for ways in which to do that. Our asset size is approaching $23 million, which is what we have under management and which we are managing and giving away as a result of gifts that we have received. And you should be aware that we do make grants totaling more than $1 million a year from our unrestricted funds. And Sunshine Cathedral receives grants almost every year in some area to support your arts organizations, your food pantry in some way. So we're proud to be a partner with you. I don't want to say a whole lot, but the next slide, Phil, you've heard a lot about what legacy giving is already. Legacy giving doesn't have to be complicated. This is simply taking what you have been given, and it's an opportunity for you to pay it forward in some way. And what a great testament to be able to do. You know, they mentioned Paul Fasana, one of the first people, and Paul was a great guy. And I didn't know his husband, Robert Graham, but what they have done, their names, their impact, their beliefs will continue because of the steps that they took. So that's really, really important. Two other quick notes, and then I'm going to come back at the end to answer some other question. But what's very important is to remember that anybody can leave a legacy. You don't have to be a Rockefeller. You don't have to be a Carnegie. You probably have, and as Jarrell mentioned, you may be living on your IRA or living in your house, but at some point, that's going to be worth something after you're gone. So anyone can leave a legacy, and it's the combining of those that really has impact for our community. The second thing I'll say is that typically involves a team. This is not, so the team usually involves the organizations that you want to support, such as the Pillar Society for our Sunshine Cathedral Foundation, your wealth advisor. Where are you? Do you have enough money to live? How long is it going to last? They are part of that conversation. And obviously your attorney, because that is going to be the individual that helps you set it up and take care of those plans so that your family isn't fighting or anyone else. So it does take a team to do all of that. And with that, I'm going to introduce Chuck Lane, he represents the wealth advisor part of that picture.
Thanks, Mark. Well, good morning, everyone. And I'm going to be very brief because I don't want to take time from the two gentlemen that are going to follow me, because I like them and they're good friends. And besides the fact they're attorneys, they're still likable and still good friends. Anyway, I've known Jeff for many, many years. I'm not going to give away his age too badly, but 30 years ago, when I did my first set of estate documents, this gentleman did them for me. So that shows you how long I've known Jeff. He's a fine gentleman and a great attorney. So if you have questions regarding estate planning or don't have an attorney, Jeff would be a great choice. Marco is also a licensed estate planning attorney, and he happens to work on our team at PNC. And Marco has a great sense of humor as well. Our job, Marco and I work on the same team, and our job for PNC is a service we deliver to meet with individuals, whether they're clients or not, and educate them in many areas of their finances, but mainly one of the key components is around estate planning. Because many clients we see have everything from nothing in place to a handwritten will in place to a full set of 5 key documents. Obviously, we want everyone to have that far right side of having all 5 key estate planning documents in place. And so they're going to answer questions and give you kind of the outline of the structure of what does my estate plan, should it look like? What documents is it composed of? How do I get those documents? Do I need all of the documents? Some people say, I need just a will, or do I need a trust? Do I need other documents besides a will and a trust? They're going to answer those questions and cover the basics of how that happens. So, one of our jobs, as Mark and I and Jeff are all fiduciaries, is to help individuals set up their documents to protect themselves and plan for their legacy, or where their money goes when they're no longer with us. One of the things personally I feel is the biggest decision you'll make in all of this planning process is deciding who is going to be in Florida, they call it a personal representative in your will or in your trust, your successor trustee. Because that person is going to be responsible for executing your wishes. And sometimes people think, oh, it's an honor. I'm going to name so-and-so because it's such an honor to be my executor or my personal representative. But really, it's a very challenging task. There's deadlines, there's penalties, there's things that if aren't done properly can really mess things up. So think twice about who you pick. And obviously there are corporate individuals that can serve as well, that make sure individuals like Jeff as an attorney or PNC as a bank can do those things on your behalf And that way, you know your wishes are executed exactly like your documents say they should. Whereas an individual may or may not do exactly like you wished. Even though there's a liability there, I've seen many times when things aren't done properly. So with that said, I'm going to ask Jeff and Marco to come up, and they're going to go through the kind of the main components of the estate plan.
Thank you, Chuck. I'm very honored to be here. I've been involved with this community for a very long time. I don't know if anyone remembers, but before the church was here, they had a space behind Lester's Diner. Does anyone remember that? And I went there for the first time 40 years ago, 1983. And then obviously I became a little bit involved. I was on the board of the Sunshine Cathedral Foundation, formerly called the Sunshine Community Foundation. And so I used to come here for meetings, and I had the honor of meeting people who, endowed many of the projects here, like Paul Fasana and Robert Graham and Walt and Steve. I've known all those people. But anyway, I've been, very proud to be practicing law here for almost 40 years, and still going strong, building a new office on Wilton Drive. But, my goal is whether, whatever attorney you use, you should have at least the, basics of estate planning. And the basics really consist of 4 documents that I always tell people: a living will, a durable medical power of attorney or a healthcare power of attorney, a durable general financial power of attorney, and a last will and testament. And I'll briefly describe those documents. So the living will is the document that says, if I have an incurable injury or disease where life support's only prolonging the moment of my death, I don't want to be kept alive artificially. I don't want to be intubated. I don't want to be resuscitated. I don't want to be put on feeding tubes. I don't want them to start treating a newly reversible condition. But this is only where a doctor and a consulting doctor, an additional doctor, 2 doctors have certified that you're not going to live whether life support is used or not. You're either end-stage condition, persistent vegetative state, or terminal. And so you're going to name someone that you trust, maybe someone with a little medical background, a relative, a friend, to make those decisions for you. Everyone probably remembers that case with Terry Schiavo back in 2005. They kept her alive for years with appeals. Jeb Bush was involved. President Bush was involved. They kept her alive. And her husband had testified that she wouldn't have wanted to be kept alive artificially. But she didn't have that document. It's really important to have that document. And then hand in hand with that is the medical power of attorney. And that's for all medical decisions, not just life support. And if you already have these documents, you've really got to check them, because the healthcare power of attorney should have a HIPAA release. HIPAA is the Health Insurance Portability and Accountability Act, and it lets medical providers refuse to release your medical records unless you've signed a release. It's a privacy act. So you've got to check.
And by the
your
way,
documents.
anybody, can you hear me? Just Joe. Anybody who has children, by the way, who are, above the age of majority, those children should have those forms as well. The HIPAA release is very important. Just an example, I have a daughter who's 24. I'm certainly able and willing and forced to pay the bills. But if I call the doctor, I can't get any information. So you should make sure that anyone you have in your family who you feel needs that, it should be in place as well.
Absolutely.
Yeah.
And then the general power of attorney is very important to check that as well, because the law changed in 2011, and it's very important you have updated documents. So, and also what happened, the pandemic came along, and guess what? A lot of people took their old 3 or 4 or 5 page powers of attorney, and their agents try to use them. So they would go to Social Security because mom's check stopped coming. And Social Security would say, well, it doesn't say they can represent you in front of the Social Security Administration. So those powers of attorney, particularly during the pandemic, went from like 5 or 6 pages to 16 pages.
And now there are little initials you must put next to each one of those areas that you want someone to handle for you. So it's pretty specific, and it allows you to make changes even to some of the other estate documents, which are not, just generally speaking, able to be done just because you have a general power. Also, just many clients of ours don't really realize that a durable power of attorney stops working when someone dies. And we've had many occasions where somebody said, came in and said, well, I could still do something. I know you can't, and that's why some of our planning discussion will talk about trust, which Jeff will introduce.
Right? So that's absolutely correct. New powers of attorney, you have to initial certain powers in order to be valid, like the ability to change a beneficiary designation or to amend a trust or create an estate planning document or to disclaim assets you have coming to you. It also has something very new called the Florida Fiduciary Access to Digital Assets Act. So a lot of you are doing your banking online. You have usernames and passwords. How is someone going to get those if you become incapacitated? Not everyone leaves a list. So we have that in the new power of attorney, and that person you name to have the power will be able to get your usernames and passwords.
And one comment with these documents, they're very important. And I said this to Jeff the other day, but I would say that during your lifetimes, there's probably no documents that are more important than the living will, healthcare surrogate form for the most part. Those are related to how we get treated. But there are so many individuals that just don't realize that that needs to be in place. And we have clients all the time that go back to an attorney and get things done. They tell them they don't need an updated this or an updated that. You need to have everything updated. If you go to an institution with a very old, durable power of attorney form, for example, they may turn you away. They will say no initially because they just don't know. First of all, you have more than 2 children. You might have 3 children, 4 children. Someone is named, but from 15 years ago. How do we know a new one has not been done? So updating documents is actually important criteria for somebody who looks at it and says, does this make sense? Also, living will, if anybody's gone to the hospital or had any procedures done, I've had a couple. And that is the question they ask you 30 or 40 times before you actually settle into a bed. Do you have a living will? Do you have a living will? They can't ask you enough. So these documents are extremely essential to have,
Marco, that's a really important point. Estate planning is not just about what happens when you pass away, but it also governs what happens during your lifetime. If you become incapacitated, if you can't make a medical decision for yourself, if you can't go down and speak with an IRS agent or a Social Security Administration officer. So you would want to name someone, you'd want to have updated documents.
Yeah.
And then, of course, that leads into those documents, like Marco said, terminate upon your death. So then a will takes over. Your power of attorney is no longer valid. That agent can't go into a bank. You would need an executor or a trustee under a revocable trust. So obviously everyone knows what a will is. It's a document that takes effect upon your death, and it governs the disposition of your assets. That would be tangible personal property, real property, and all bank accounts and assets that do not have a designated beneficiary. And Marco's going to talk a little bit about this, because if you have designated beneficiaries on an IRA, 401k, a life policy, you have to be very careful that your intent is carried out, because your will may intend to leave equal shares to different relatives or friends or
Correct.
partners or spouses. But if you can skew it the other way by having a beneficiary designation that does not coordinate with your will,
Yeah.
and it may become
And if you can go to the next slide, Phil. On this, it talks about different types of ownership and how it passes. The top says joint ownership. And so there are very often people will say, I'm going to leave child or loved one as a joint owner on an account, and I'm going to allow that individual to give the assets to others. I hate to say it, but there were a couple of comments before about the turmoil that could be caused by money. It is real. And it happens. And you cannot have one child or one individual that you're going to think you're going to trust to pass assets to others when you die, because it is easy enough to put more than one on a joint account. You can have several children or several individuals. That's if you're going to do that. One of the biggest things that we see, though, and Jeff and I were talking about this, is that you will have a will that says, I want to divide my assets equally among these 3 people. And yet, you then have a joint account. And if every asset of yours is held jointly, I hate to say you don't need a will, but because the joint asset is going to go to the joint owner. Now, in the state of Florida, I just think it's good to mention for those individuals who are married, you want to make sure that you can take advantage. If it's joint, it should be joint tenants by the entireties. It's a different terminology, but it allows greater protection than just a joint account. And it's in the state of Florida. Not every state allows it. So knowing that if you were preferring to have an asset held jointly rather than have it in your individual name or in a revocable trust, which we'll talk about, You should make sure it's held correctly. If you're sued and you have one spouse who's being sued and other spouse is not party to that transaction that caused the suit, very good chance that you will not have to pay out of that joint account. You'll have some greater protection. So it's good to know. The other thing, when we talk about doing planning, we talk about your basic planning. People forget that there's an IRA that has a designated beneficiary page. You could name individuals. If you don't trust those individuals, as Jeff and I were talking about too, we have a lot of times we might have one child who is a spendthrift or one individual that may blow through the money very quickly. What do we do? Well, you can name a trust as the beneficiary of the IRA, and then that trust can dole out the money on a logical basis that you think would be helpful for that individual. So the other thing is that we have a lot of times many clients who will forget to change a designation if somebody had passed away. So a spouse passes, we forget to change a beneficiary on where? Annuities, life insurance, IRAs. Those are your three main areas of investments that you should be careful about changing should there be a change in circumstance. What are some of those changes, by the way, that take place? You know, there's a birth in your life that you see a friend, family member has a child. There's a divorce, obviously something to worry about. And by the way, you know, divorce, just so everyone's aware, the federal government did a study recently and they find that the major cause of divorce is marriage. So just want everybody to be aware of that. So just because we all have a right to marry, we should all think about that. That, by the way, the percentage of divorce or the rate of divorce is the same among straight or LGBTQ families. So we should just all be aware of that. And the other thing is that when you have somebody who does not remember to change a designated beneficiary, for example, on a life insurance policy, if you had a spouse who you divorced and you don't change it, that person's going to get that policy. I would prefer the church or our fund to, you know, get that policy. If you have no one else, wouldn't that make more sense? Yes, because you got divorced for a reason, right? So those are some of the things that just arise. I know that when we talk to people about basic planning, they don't always do all of the planning.
Right. So one of the things we do examine when I have a client come in is we look at those assets that have designated beneficiaries. We look at the title on property. And one of the things I've been noticing recently is a lot of title companies, when you buy your primary homestead property, they won't ask what form of title you want to take it under. And if it doesn't say, if it just says John and Jim, it's presumed under Florida law to be tenants in common, which means you each own a 1/2 interest. So there's been a lot of surprises lately. People come in, someone will come in and say, my spouse has passed away. And we look at the title to the property and they were assuming it was a right of survivorship and it wasn't. So we actually have to bring an estate proceeding to get that 1/2 interest in the spouse's name. Now, typically, let's say you are married. Typically, if we do a will, we do reciprocal wills, and the spouses may say to me, well, everything has a designated beneficiary. So there may not be an estate proceeding on the death of the first to
Correct.
die, because everything will pass by right of survivorship, and the will not have to be probated. And typically, the property is tenants by the entireties, which is the married form of rights of survivorship. But I think Marco made an amazing point. You really have to examine every beneficiary designation, because if your beneficiary is deceased or it's not current, there are a lot of unintended consequences. For instance, if you have a beneficiary designation of someone who's deceased and don't have an alternate, it could be payable to your estate. Maybe that's what you intended or not intended, but it's important to do. And when it comes to IRAs, yes, if you're worried that your beneficiary will liquidate it and spend the money unwisely, you can have it paid to a trust. We put in a provision there called a conduit, and they get the payments over time. And what you have to know is, in the old days, an IRA, your beneficiary, other than a spouse, that's an exemption, used to be able to take it out over their whole life. A spouse can do
Extended
that.
over their period of
Extended
their-
over their life. The IRA administrator will say the required minimum distribution is X, and they have to start taking it on the December of the year following death, regardless of whether they're 70 and a half or 72. But right now, we have the Secure Act in 2020 changed all of that. A spouse can still take it out over their lives, but your IRA beneficiary must now take it over 10 years. So that's very important. Did you have a question? No. Okay, so it's very important to know your beneficiary designations. And then we'll kind of
We'll go to the next
transition
slide
into-
maybe
yeah,
on
next
wills.
slide.
I think next one is on wills.
Yeah.
Yeah. You want to start?
Okay, so when we do a will, we talk about personal property, furniture, furnishings, rugs, pictures, books, china. This will is something all of your beneficiaries are going to look at, and you have the opportunity during your lifetime to direct exactly what you want to happen with everything. So one of the things lately I think is kind of funny is I had an estate where personal property was left to 5 or 6 nieces or nephews, and one of them said, "Well, I want the love seat." Well, it costs like $1,000 to ship the love seat to California. So lately, I've been putting in that the recipient will pay the shipping costs. But I like to put in there that the personal representative has full and absolute authority to gift the items to friends and family, because there's no secondary market for your furniture or artwork unless it's very valuable. You have the right to do a list, leaving certain items to certain people, and direct whether the shipping gets paid. But you can do specific monetary amounts, like a certain dollar amount to each niece or nephew or friend. And then the remainder, the residue, we call it, is typically in percentages because you don't know how much you're going to be left with. So,
We've had a situation not that long ago when we talk about percentages and how much we're going to leave this individual, that entity. And so we had been at a retirement community in Fort Lauderdale, and so we're talking to this prospective client about the planning that was done about 20 years prior, and there were individual gifts being given out, specific amounts, 30,000, 15,000, 80,000, whatever, well thought out 20 years ago, and the assets grew so substantially that when I said to the gentleman, I said, "Are you planning on leaving $4 million to the John Knox Village Foundation?" And he said, no. I'm giving most of it to my friends and my family. I said, "Well, no, you're not. 20 years ago you were, but through the years he had actually inherited monies, and there were other monies that built up his estate significantly." So the point about leaving percentages may also work even with specific bequests, meaning if you use up all of the money, you didn't know you were going to have a long-term care health event, that remainder of your estate was dwindled down to 100,000, giving out 50,000 to 5 people is not going to happen if you have 100,000 left in your estate. They'll do usually like a pro rata type of number and give you something because the intent was to give. But if your real intent was to leave a residuary amount to the person you really love, and there's no money left because of those specific requests, that's where percentages may come in handy. Leaving 5%, 5%, 5%, the balance goes to whoever or wherever. And it could be an institution as well.
Right. And there is some good news regarding your estate. Florida has no estate or inheritance taxes whatsoever.
Correct.
So your heirs receive those funds free of estate tax, inheritance tax, and also if you have a stock portfolio and you're leaving it to individuals or to our fund or a charitable organization or foundation, it gets the step up in cost basis to date of death value. So when it's liquidated, there are no capital gains taxes to pay. Now, on the federal level, the exemption this year is $12.9 million.
Yeah.
And it's going to sunset, though, on December 31st, 2025.
So in January of 26.
Right. It's going to drop down to 7.
They're saying about 7 million because
Yeah.
right now it's 12.9. I mean, these numbers for the average family in this country, they aren't affected,
But I hope you all have to worry about this.
I hope you all are really, really scared about it. But if you're not, people did years ago worry about, because the exemptions had started at 600,000 and then worked its way up to 1 million. Then it went up to 3, and then it went back down. In 2010, by the way, the estate tax had gone away, right? And the only person that knew when to die that year was George Steinbrenner of the New York Yankees. So because he knew he wasn't going to give away or sell the Yankees, it was staying in the family, and so capital gains didn't come into.
I had a wealthy client, a lovely lady who lived in Hillcrest, and her last note to her son was, I'm sorry I didn't die last year. It was actually, we still talk
Well, you know,
about that.
they were very nervous, though. You know, literally, December's rolling around mid-December, and they were afraid that, you know, there's no tax this year, and in 3 weeks there is a tax. You know, will people do the wrong thing? You know, so that healthcare surrogate form that says you make healthcare decision, that does not include the expression pulling the plug if you're having your knee worked on, and you know, you say, I'll be fine. It's just a knee. It's ligaments.
But also that
so-
exemption's portable. So even when it drops down to, you know, 7 million or whatever,
Correct.
if you're married and your spouse dies first, you can port their 7 and get a $14 million exemption upon the second of you to die,
Yeah.
and not pay anything upon the
Correct,
first.
correct. You're able to carry that forward so you don't really lose it. Because it used to be you either use it or you lose it.
Correct.
And that expression was never more true, especially when it was a lower amount. And many families did meet criteria of 600,000 to about 1 million across the country. But they would set up within a will some tax provision. The tax provisions are setting up what's called a credit shelter trust, people may have heard, or a bypass trust, or an AB trust. An A is the marital trust, and a B is the bypass. B also stands for below ground. Sorry,
Right.
the person who had passed would be leaving that to their significant individual in their life, their spouse, right? So the spouse would live on those assets and then pass it down to children or any other individuals that you wanted. But it used that exemption. If you did not set it in that way, that first spouse that died, you would have lost that exemption except for the portability now. So,
Right. So let's talk a little bit about trusts.
Yep.
It doesn't have to be that complicated, but a trust is a document that's established during your lifetime, and it comes into effect during your lifetime, unlike a will, which is only effective upon your death. So when you create this entity called a trust, you occupy 3 positions. You're the grantor who established it, you're the trustee who administers it, and you're the beneficiary. And the trust has all the dispositive provisions your will has. In other words, how your assets are to be managed during your lifetime and upon your death. So you would have, obviously, most people are their own trustee, and they would manage their assets. And the goal is to retitle your assets that are non-retirement accounts into the name of your trust. So your property would be retitled into the name of your trust. Your individual investment accounts would be retitled. Your bank accounts, checking, money market savings. The retirement accounts would not be, because changing the title on a retirement account is a taxable event. But we would examine the beneficiary designations.
Right.
For instance, a life policy may have the trust as a beneficiary because that's not a taxable event. But on an IRA,
so just to be clear, having a revocable trust, that document being the beneficiary, is completely different than having that trust own or being the title owner of that IRA, because that is what the taxable event. So somebody has 300,000 in an IRA. I change that ownership to my revocable trust. I now have 300,000 of income I must declare this year. No one wants that. Okay, but I've seen a lot of clients get this close to doing it, you know, making a mistake.
or even the brokers have to be educated, because
Right.
what's happened to me is the client has changed their investment account, which contains an IRA, and it causes a big problem.
Yeah, exactly.
But that's a whole other
exactly.
story. So it's not a complicated concept. It's just an entity you establish during your life. It holds your assets. You use your same social security number. Nothing changes in the day-to-day administration of your affairs. The only thing different is the way things are titled. And the beauty of it is, if you become incapacitated or deceased, you have a successor trustee, a trusted person you name, to take over the administration of your trust, pay your
Yeah.
bills while you're alive, etc.
I was just going to jump in because that's extremely important, you know, because when you have a will alone, you go through probate. It's a lot of time consuming effort there. So with the revocable trust, you don't. And the transfer of power, I like to say, is almost instantaneous. Okay. So for example, I die and I have the revocable trust with my assets in it. After the normal mourning period of 2 hours, my wife is going to be able to go and start selling assets.
And dating.
And right, so at least maybe it's more than 2 hours. I don't know, but it won't. You know, with a revocable trust, you don't have to worry about being, you know, subjected to the court's decision on timing. Probate, just so we know, when we have a will alone, just a will, and I say just a will, I still prefer just a will than just nothing. Because remember, we talked about doing some giving and some legacy planning, right? You can't do legacy planning without the planning. You need something in place to be able to target what you want to have happen later on. And a lot of clients don't realize that. But the probate is long time delays. They call it higher cost, and they blame attorneys many times for those higher costs. But we're not going to blame Jeff, okay? And lack of privacy. So, for example, lack of privacy. Everybody, who's a certain age will remember the fact that Jacqueline Onassis died. She was a resident of Manhattan, New York, right? And when she died, within days, not even days, I think there was a couple of articles that came out that said she's worth only $2.5 million, Jackie Onassis. Anybody believe that Jackie Onassis was worth $2.5 million? Okay, this is what happened. Only her co-op in that Manhattan high-rise was not allowed to be placed within a revocable trust. So they were able to find the value of the co-op, and that's what was being put onto the probate.
And the will is a public document, so anyone
Anybody
can
can
go down
come
and get a
see it.
copy of your will. Was a trust is private; no one can
Correct.
see it unless they're a beneficiary.
Correct. And so having the revocable trust, I just as so everybody knows, that incapacity is one of the most important issues. Think of it. When you die and you leave your assets, what happens? Does it matter? Not if you do some planning, that's off your mind. However, if you're alive and you become incapacitated, that's important. That's important to every one of us. So when I speak to attorneys like Jeff, I'm looking at documents. I review documents for our clients. I make sure it has language in there. I personally like to see 2 sentences. I want to see it say that I, as a settler, when Chuck is not well and he's going to live in their basement in Philadelphia, and Chuck saying, no, I have a beautiful place over here in Florida. I'm not going to Philadelphia. The problem is you need to state what you want to have happen, especially if you're using a trustee who doesn't know you all that well, like a corporate entity, even an attorney who might be in place. You need to make sure you detail it.
Right? And just to
Anything you
circle,
want to summarize, you'll summarize it.
yeah, well, just to circle back. So let's say you have a will or a trust. It's an estate planning document, and if you have charitable intent and want to leave a legacy, a lot of people in the past, before we had our fund, they would name a list of charitable organizations, and then maybe they would change their mind. They'd come, we'd redo their will, we'd do an amendment to their trust. But one of the benefits of leaving to our fund is you can state in your documents that I leave a certain percentage, 50%, 100% of the remainder or residue of my estate to our fund to be administered in accordance with my statement of charitable intent on file with our fund, as it may be amended from time to time. So you don't have to amend your trust or will. If you name our fund and you want the Sunshine Cathedral Foundation or other local charitable organizations to be the benefit of your generosity, then you have a statement on file at our fund. You tell them exactly your statement of how you want your assets distributed. Maybe there's a certain mission statement that you would want to create with them. And you do never have to amend your will or trust, because you just go down to our fund and they amend how the money's going to be administered that they're receiving. So it's a tremendous benefit, and they do a fantastic job at it. So thank you, Mark.
Yeah. And we're going to be here for questions. So, we're going to throw it back to Mark. Oh, you have something now? Yeah, go ahead.
So Florida has a statute, 732-103-102. And it states that if you die intestate, then it would first go to your spouse and children, if none to your parents, if none to your siblings, and if none, one half to your maternal aunts and uncles and their descendants, and the other half to your paternal aunts and uncles and their descendants. And there would have to be an intestacy hearing so that a judge would enter who was entitled and in what proportion among all your relatives. So that's a great point of unintended consequences, and it happens quite a bit.
And somebody's going to be named to handle that whole affair like a probate proceeding. So it's always better to have something in hand saying what your wishes are rather than let the state decide.
That's a fight in and of itself, because I have one right now where a friend is petitioning but there are 38 relatives and one wants to be appointed. But my people who are relatives don't want her. So we say, well, she has no standing because she's not been determined to be related to the decedent yet. So yes, please do a will or a trust or an estate plan with any attorney. It's easier. Yeah. Well, we don't have any sort of a registration, but we have a law, it's reciprocity, that if they're valid, were executed, Florida will honor it.
Thank you for your attention. We are in the home stretch, folks. We're almost done. This is kind of like when Pastor says in his sermon, in conclusion, and then you know, okay, I can breathe and we're almost there. Jeff really just set it up really well for us because one of the most common questions that I'm asked, and to understand what the role of a community foundation or what our fund foundation can be is, should I give my gifts directly to nonprofit organizations? Do I do direct philanthropy to those organizations, or should I do it through our fund foundation or through a community foundation? And what are the benefits and the advantages of going in those two ways? So if you go to the next slide, Phil, this is one option. You can always write in your will or your trust that Marco and Jeff just talked about. You can put a list of organizations. And again, per their comments, it would probably be in percentages. It would not be in dollar amounts. But you can certainly say, I want to leave, X percent to organization. Why? Go right down the list. As long as it's 100%, your gifts could go directly to those nonprofit organizations, the part of your estate that you want to include and to make philanthropic. If you do that, you need to be aware of a couple of things. One is that receiving organization now has complete control over that gift. So maybe you wanted it to last for 15 or 20 years, but that organization is going to have the control as to whether they run through that money more quickly or not. Another thing to keep in mind is, what if it's a significant amount of money? Do you want to leave $500,000 to the local chorus or to a arts organization? You really need, because are they equipped to manage that kind of money? Will they make sure that it lasts for a number of years? So it's very important to think about these things. And as Jeff mentioned, what if that organization falls out of favor with you? Or a new organization comes into your life and you say you want to include them. Where do you have to go make those changes? Back to your attorney. You have to update your will. You have to update your trust every time any of those nonprofit organizations that you want to support or not support any longer want to make the change. But at the end of the day, philanthropy still takes place. And one key point is that what works for one individual won't necessarily work for the other individual. But this is always one option: direct to nonprofit organizations. The second option is what you do, and Jeff described it. The beneficiary, the philanthropic beneficiary, is our fund foundation. In your trust, in your will, you say, I'm going to leave my residual estate or a specific amount to our fund foundation. And then I'm going to add one more document that he mentioned. You've heard a lot of documents. There is this document called the Expression of Charitable Intent that you file with us, and that captures what you want us to do with your money. Now, why do that? If it's a significant amount of money, we are the trustees. We continue to honor your intentions. So that if you want it to last for 15 years, guess what? It's given to that organization over 15 years. Or if you had a specific purpose, you said, I want it to go, and Paul Fasana did this. Paul left a gift specifically for the maintenance of the chapel. So we distribute that on an annual basis, send a check to Sunshine Cathedral Foundation and says, This is the annual money from Paul Fasana that he left specifically to support the maintenance of the chapel. And that money will always be there. One of the ways which you can also give in this manner is, what if you end up with 2 or 3 organizations and you've only got to like 60% of your estate? With a community foundation, you can say, you know what, I have a heart for a specific cause. Maybe it's social justice and equity. Maybe it is youth. Maybe it's something related to health. You can name areas of interest rather than specific organizations when you do a gift through a community foundation. You know, who is to say what the most pressing needs are going to be in 20 or 30 years? We can't really predict what that is. So you may be leaving money to organizations that are not as effective, not doing the same thing, but if you leave it to an area of interest, then we distribute it according to that and our process. And if it's an area of health, it might be one organization one year, and the next year another organization is doing a great job. So you can do areas of interest rather than just specific organizations. The last thing I'll say is that every one of these is unique. As unique as your will and your trust is, the expression of charitable intent is also. And what we like to do and what we really have to do is sit down with you and find out, what do you want to see supported? And some people come to me with a list of 10 organizations, 10% each, and that's how it will be distributed. Some people come and say, I'm going to choose 3 or 4 organizations, and then I'm going to make the rest unrestricted. And I will let you decide what are the most pressing needs of the day when I do pass away, and that's the area. So at the end of the day, philanthropy takes place whether you do it directly to organizations or through a community foundation, and it really depends on your situation and how you want to see that money handled. Bill?
Thanks, Mark. I'm going to ask Mark to remain up here, and I'm going to ask Jeff and Marco to join him. This is a time for you to ask questions, and it's not try to stump the panel, but I'm sure they've heard most all of them. One thing I did want to add just really quickly, Keith was talking about the Pillar Society and that the fact that the foundation doesn't have actual on-site staff. So one of the things we've begun some early conversation with the Our Fund Foundation is administration of the Pillar Society. And so we're starting to go down that road to leverage some of their capabilities there as well. So I'm going to turn the floor over to these gentlemen to answer your questions. I'm going to start with one because I've got the mic. Relative to trusts, can a trust be jointly named and with dual beneficiaries?
Okay, a married couple can do a joint trust. I mean, typically single people do not do joint trusts. One of the reasons for that is step up in cost basis. You don't want to combine the assets.
Or generational, you want to be careful who's involved as a joint owner of a trust.
Correct.
But yeah, I mean, absolutely. And by the way, we suggest that. I don't know if we use the word suggest. We give the options that people have available to them. You could do 2 separate trusts, revocable, or you could do 1 joint revocable trust. Depending upon the size of assets in one's name or state is sometimes indicative of what they should do. Years ago, I had brought up that the exemption was very low at one time, and then people would do a joint trust, and when one died, there was some concern. We don't really know which person those assets belong to. Like, how do you divide them? There's not a great concern if you're below the exemption amount. So, because even if one died and you had 2 million total, if it's still below the then 7 million it comes down to, it doesn't matter. And the answer will be no, it doesn't matter.
Two separate trusts versus a joint. Sometimes titling of accounts can be problematic because you can't have a checking account owned by 2 separate trusts. So it would make things more challenging to have 2 separate checking accounts. So that's just
That actually happens a lot, and I tell people, yes, you can keep your house account joint with rights of survivorship, but upon the death of the first of you, make sure the survivor retitles that in the name of their trust.
Yeah, that was one of the questions before when we were talking about wills, that if everything was held jointly, and you have two wills and one dies, you didn't need that first will. But there are situations where you want to make sure that that will would then be in place already for the survivor, because it could have been, unfortunately, a common disaster type scenario that caused the accident that caused one to die and one to not be all that well, could not necessarily now go and set up a will. So good to know it's in place, because then that joint ownership will go to the survivor, technically, and would then go through that survivor's estate, and the will is there already in place. So good to have it prepared. Yes, Keith. Yeah, I'm going to let the yeah. The question for anyone who didn't hear is there a package price to do the trust and all these various documents? I'm going to let unfortunately, the practicing attorney actually answer that. I tell people, by the way, I prefer when they do a set price, just as experience will dictate, that you know what you are in for. It's okay if somebody like Jeff is an attorney and says, I go on an hourly basis. I charge usually about 7 hours worth of time, and it's $3,500. It's different if you then get the bill from Jeff and it now says $8,000. And it may not be his fault. It may have been that you called him 30 times and we're on the phone an hour each time. You think his time is free? No, he just told you he's on an hourly basis and he has every right. So my point is, I just tell people, you figure out, the attorney can tell you what your price is. And Jeff, I don't know your thoughts.
You know, we do have a package price for the basic estate plan. It's about $9.99 a person. That's the living will, the healthcare power of attorney, the durable financial power of attorney, and a fairly simple last will and testament. Once you have
So it's less than $10 each, which is
yeah.
You said sorry.
$999.
No,
But, you know, of course, if you have a complicated will where you want to set up testamentary trusts, because there are living trusts you establish during your lifetime, there's a testamentary trust, which is in your last will and testament. It says, upon my death, half will be held in trust for my nephew, who's a spendthrift, and he'll receive, you know, a third at 25, half the balance at 30, and the remainder at 35. So then we're talking about where I keep track of my time and do hourly.
It's more of a complex scenario, more
Yeah.
needed.
And a basic trust package for a single person is about $2,500 and includes the living will, healthcare power of attorney, and financial power of attorney.
Two things. That actually is a very fair price, but it ranges based on scenarios of actual locations, what city you are in, other factors in terms of firm and firm setup. So very large firms have several layers of individuals working on that same document, and that same document could end up costing $6,000 because several different individuals have to touch it and approve it. And it's sort of the way things are done. Doesn't necessarily mean it's any better than the other document. It just means that it's a different setup.
We all basically use the same programs. I try not to do the
Perfect.
fill in the blank programs,
Yeah.
but I see a lot of trusts by fancy firms, and it says, to my lineal descendants or my spouse, and it doesn't even name them.
Yeah, exactly.
So,
exactly.
it's like, it's
Yeah.
crazy stuff.
Yeah.
Yes.
Oh, by the
Free.
way, and
Free.
and to that point, it's actually an excellent point. I had mentioned earlier about trustees. Maybe it's a corporate entity. Corporate trustees, we are fine in acknowledging and following your designation of, I want 50% to go to the Sunshine Cathedral, 50% to go to our fund. But we're not really good, a corporate entity, at saying you leave it up to us to decide where it goes. Whereas that is what that is doing for you, which is really a plus. But we certainly can be engaged to give the money to an our fund or to the cathedral. It just how you prefer to set it. Yeah, yeah. there's two ways of looking at it. You want to start? I'm
Well,
sorry. Go ahead.
that's funny. If they're all gone, we have sometimes we put a clause in called the beneficiary of last resort.
Right.
So you would say then it goes to our fund.
Okay.
But you're right. We work in hypotheticals when I do these documents. So if you have 10 beneficiaries, one may be it goes to their lineal descendants in equal shares, but if none to the other 9 beneficiaries, each one may be different. Someone may not have lineal descendants. So
They
yeah,
don't
you
have children.
Yeah.
So it goes then divided now among 9 instead of the 10. But if none of them have children, and that's your goal, that's exactly what would happen. If they survive, it will say, it shall go to Mr. Smith. If Mr. Smith does not survive, it shall lapse. It will go back into the pot and now divided 9 ways. So, yeah. And the term that you may see in there, if it were lineal descendants, is per stirpes, PERSTIRPES. It's just a legal term that means it's going to go to your bloodline.
down
So-
the branch of that tree.
Right.
Yeah. As opposed to per capita, where that inheritance may go to all of the beneficiaries. It would go per stirpes down that line.
Sure. Yeah, I mean, the unfortunate part is if you just don't like their children and you die, it goes to that person, they live one day and it goes to their children. There's nothing you could do about that. Well, you may be able to do. You could leave it in trust for that individual to live the remainder of their lifetime. Should they not use up all the funds, it can go to someone else. So you can do it, but not all the time are we leaving amounts of money that make it worthwhile or prudent to start setting up individual trusts for the 100,000 I'm leaving here, because the cost associated, somebody being trustee could eat that up a bit.
I love that gentleman's question. Everyone, I get this a lot. Is there a registry for wills? Where do I put my will? You really have to have someone trusted to hold on to it or know where it is. Florida used to, many, many years ago, permit you to put wills on file, but the problem is you need the original. They have like a mile of warehouses now with wills. They don't know whether the people are alive, dead, moved away. So
I was just going to add to that. One of the other things, it triggered something in my mind about, where do we keep things? I always have people they'll tell you, with the healthcare surrogate and the living will, they leave it in their safe deposit box. You never leave it in your safe deposit box, because no one gets sick Thursday at 2 in the afternoon. You always get sick Saturday night at 3 a.m. and you don't have that document, and no one can get to it, and somebody may be able to get to it on Monday. You keep those documents in a safe place in your home. You let people know where that safe place is. I don't care if it's your freezer inside of a plastic bag. By the way, actually not a bad place, because it's fireproof and floodproof many times. So, but I'm going to go right to your freezer next time. I'm going to know. But that's, you want to keep it in a safe place in your own home, in your hand. And if it's lost or stolen or destroyed somehow, you ask for a new one to be done. It's not that difficult.
Okay. Well, a good attorney would say, I leave it to this charity or their successors by merger or otherwise. So if they do have a successor organization, it would go to them. But if not, Florida has a law. It's the law of Cypres, CYPRES. And it says it would go to an organization of similar intent. So I've had to go to court. One was, we had a person, I think we know who is, but left a bequest to Cocker Spaniel Rescue of Broward County. I was called Cockers and More at the time, but they were out of business. So I filed a petition to determine a Cypres beneficiary, and it went to Cocker Spaniel Rescue of Broward County. And the woman who ran it, Terry, she was just overjoyed because it was a significant bequest. But the judge ruled that was the only other Cocker Spaniel Rescue organization in Broward County, and that was the testator's intent. Great question.
And you could state that the organization must be in existence at the time of my passing, and if not, shall lapse once again and go back to the other
Sure.
organization, if that is part of your goal. Anyone else? Keith, you were going to say? Oh,
Yay, pillars.
Yeah. 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 I wanted to also add just one other thought for individuals that are charitably minded and have a certain amount of assets, either now or in the years to come. They can set up a charitable remainder trust as well. And the reason I say the charitable remainder trust, because it works if you're very altruistic and want to give a lot of money away, or it works if you're a little bit less altruistic and you want to keep those, your hands somewhat on the asset. So you give your annual gifts, you give, ongoing gifts to organizations, which we actually try to have clients do that all the time, especially the more wealthy ones. Why not? Why not give it away? It works great as a tax deduction. But a charitable remainder trust works great. You get a deduction for your charitable gift into that trust, even though the charity is not getting anything yet. But as you get an increased income flow, you can actually give some of that increased income flow to an organization on an annual basis. There's no rule against that. So people think, well, I don't really need the income, but I'm getting 2% dividend, or I'm getting 6% flow. That extra 4%, I can give away to an organization, to Sunshine Cathedral or to our fund. It doesn't matter. And you can get additional deductions for doing so. So you can give it away because we're just fully altruistic, or we could give it away and give more away because we can use some benefit on taxes as well. Thanks. Thank you, guys.
So hopefully this has been informative and enjoyable with some of the humor. First of all, I want to thank these gentlemen for coming in and sharing their time with us this morning. A lot of really good information. I would encourage you to, take any and all of the brochures and articles that are available here. In addition to Reverend Dr. Darrell Watkins, I want to thank our executive minister, Reverend Dr. Robert Griffin. He's somewhere floating around, but he's always behind the scenes, and we're talking, or I'm texting him at crazy hours of the day, and so we appreciate him. I also want to recognize, in addition to Dr. Keith Muller, the other members of the Sunshine Cathedral Foundation Board. We have Dr. Rosine Patterson, Carl Shearer, Chuck Lane, dual-hatted this morning. He's a board member, John Kent, Brian Flanagan, and our other members that couldn't be here this morning. So at this time, we now have a reception in the back. I'm going to leave contact information up on this slide. There's also business cards here if someone wants to know how to get in touch with these folks. But I'll leave this up. And I would say stay, mingle. We've got some mimosas and some treats in the rear just before you exit the doors. So thank you for your time. Have a great rest of the day. Oh, Chuck. Yeah. Yeah, so to Chuck's point, if you wanted to talk about your particular situation just more privately, this is a good opportunity, or to set up a time to do that at a different time other than today. So thank you again for your attendance. Have a great rest of the day and enjoy the reception.